I'll wait till it gets to the end to see what it says. Yeah, so
Well, I was going to just ask you, Todd, if you were going to make any comments.
That's what we said. Tax planning, squishy stuff in the middle, mistake. And then plan giving.
I'd like to let you know that there's more pizza back there, and our goal is to not have any leftovers. So eat until it's all gone, please. So I want to see a whole bunch of people getting up to get stuff in, because we're not quite ready to start. Yeah, it's tough. You know, if you're
marketing machine all around you. Absolutely agree. Right, absolutely. Yeah. No, it's totally. He had a plan out of something like 70% of people. Maybe it's less good, but for the longest time, right, no, I get it. In fact, you'll find it pretty entertaining. There's a whole chapter about exactly why do people why do they do it? I'm not happy with what I say. Legal fees are expensive. I think of myself. These are the ones that I spent 1.5 years as legal people. It was ridiculous. I don't think I saw myself out when I was right. No. I see it. Shocking. It's absolutely shocking to me. Of course, not from the other aspect. I was very happy to get married until we had a plan of telling me to get through the tax there and it's legal to be and predicted by everyone. Right, and now he was doing stuff picking the edges. He knows about it. He told us where he wanted to go. Forward at the age of 4. He wanted to look for a accident. His passion really in his hand. Okay, go talk to your estate. Do you think we're going to get away with that? What is the Can you hear me in the back? Yes? Good? Good. I'd like to welcome you to this special luncheon
Virginia Rivera for funding this. That's everything. Okay. We talked about this since August, and so it's finally come to fruition. And so our objective is to talk about the tax implications on estate planning, and this is being broadcast, so please silence your cell phones as usual. I'd also like to thank my lovely wife, who has just recovered from knee replacement, for picking up the pizzas because we were short-handed and there wasn't anybody else to do it. And pizza in my heart was short of drivers, so they couldn't deliver. So she's the one.
Thank you.
I don't want to take the vote.
Yeah.
Thank you.
So it's been great so far, and I'd like to now introduce Virginia Rivera. She has more than 30 years experience at UCSC, Mills College, Davis, San Jose State, in university, and 2 hospital foundations in San Jose. She has served as a senior director for planned giving at UC Santa Cruz for 8 years. She's completed coursework for a master's in mass communication. And we're doing that because this is broadcast to the world live. We have a viewer in Italy and a viewer in Kansas that I know about today, live. And she earned a Bachelor's of Science degree and marketing certification from the University of Phoenix. She's a certified fundraising executive and certified specialist in planned gifts. She has extensive volunteer experience in a variety of organizations over the Hill in Silicon Valley, Sacramento, and Santa Cruz County. And Virginia will, in turn, introduce the fine panelists that she has assembled here. And I want to thank her again for putting together the intellectual effort, and that is our dessert for today. Virginia?
Thank you. And first and foremost, I want to thank Todd for giving me this opportunity, and together a couple of experts to talk to you about the impact of the new tax reform on estate and legacy planning. I really appreciate your interest, and frankly, we didn't expect an audience this large. But as you know, there were major implications of the new Tax Reform Act, and this is a really good time to start to learn about it. I will tell you about each of our panelists. We will each make comments in the 5 to 8 minute range, and then we're going to open it up for questions. Okay, and we are going to start with Larry Kuechler. He is a CPA and an MST, both a tax and audit partner at Arboretum LLP. In his tax role, he advises companies, individuals, and nonprofit organizations across a wide range of tax and business issues. In his audit role, he oversees audits and special projects for nonprofit organizations with a special focus on nonprofit developers building affordable housing. Larry currently helps to lead Arboretum's Affordable Housing Practice Group. Prior to joining Arboretum, Larry was a partner at Berger Lewis Accountancy Corporation for 30 years. He received his Bachelor of Arts in History from Stanford University and a Master's of Science in Taxation from Golden Gate University. Next is Trevor Strudley. He's an MSc, MBA, CRPC, and CFP, a certified financial planner professional with extensive
and I took some of them out.
experience in financial planning, retirement planning, asset management, risk management, estate planning, and philanthropic planning. Trevor is not an attorney, but he is a non-attorney member of the Santa Cruz County Bar Association. He has 3 decades of experience in technology, and after the excitement of pre-IPOs, IPOs, and private equity investing, he became a partner in his wife's private wealth management firm. He wrote the book, Tax Success, to answer the question, how do technology executives and their families manage meaningful wealth? And finally, my new colleague, Tyler Hinz, is our Director of Trust and Estates and Stewardship for UC Santa Cruz. He earned his bachelor's degree in literature from UC Santa Cruz in 2007 and a Juris Doctor from Santa Clara University in 2011. Prior to joining the Office of Plan Giving, Tyler was an estate planning attorney with an emphasis on creating comprehensive plans for families and small businesses. Tyler coaches high school boys volleyball teams and was named the 2016 National High School Volleyball Coach of the Year while working for the Mountain View volleyball team. He's also a stand-up comedian. Larry, we'll have you start.
Shall I start? I shall. Am I going to sit? Am I going to stand? Let's see. Am I going to trip you up with that? Why don't we?
There we go. We've got the stand-up comedian over this end.
That's true. Get your material ready. So, you want me at the podium?
We can hear you better if you hold my hand by your thing. Yeah.
Okay, how's that? And if I drop it down where you can't hear me, you'll wave your hands or throw something. Okay, well, my task in 5 to 8 minutes is to give you some overview of the new tax law, which I'm sure you read about and heard about ad infinitum. It is the largest rewrite of the tax code in over 30 years. The last time we had anything this size is 1986. It is primarily a tax law focused on business. That's where most of the effort is. That's where most of the tax benefits are. That's where the $1.5 trillion that it's going to cost the Treasury over 10 years is going to go to benefits for business, either a drop in rates or increases in deductions. Nevertheless, there are significant provisions affecting all of us here as individuals, and that's what I'm going to talk about. Let's start with rates. So tax rates are reduced. Not hugely, not like your corporate rate, which went from 35% to 21%. For all of us in this room, our tax rates are down roughly to between 2 and 4%, most 2 to 3%. But that isn't going to tell the whole story, and we'll see that when we talk about deductions. But there is a reduction in rates. So if your calculation of your taxable income was $100,000 in 2017, and it turns out to be $100,000 in 2018, the tax calculation is, you're going to save some money. You're going to save maybe $2,000, maybe $2,500, maybe $3,000, something in that range probably. But as I said, the real story, I think, for all of us in this room is going to be when we look at our deductions. Yes. But I should also say, when we're talking about rates, that some things have not changed. And actually, this is a good story. Capital gains rates have not changed. And those rates apply not only to the gain and and this would be long-term gain, that is gain on an asset, a stock that you held for more than 12 months. Those rates remain the same and remain at very advantageous rates. Actually 0% in some cases if your total taxable income is, for a joint return under about 79,000, something like that, single 38,000. But for I think most people in the room, you're probably at a capital gains rate of 15%. Now that's, I then have to add on to that because in addition to the capital gains rate staying the same, we also still have the Medicare tax, or you might call it the Obamacare tax, or if you read tax books, you might call it the net investment income tax. They all mean the same thing. They add 3.8% to your capital gains, to your interest, to your dividends, if your taxable income is $250,000 or greater if you are married, or $200,000 if you're single. So these thresholds are important. So if you're below that, you don't hit that 3.8%. But one of the things I want to emphasize in this short time, there are changes to individuals in the tax arena, but there are things that remain the same. And so capital gains and the Medicare or Obamacare add-on tax continues with what we've had in the past, same as in 2017. The big changes that we see, again, individually, there's huge changes in corporate and international and that sort of thing. Individually, I think have to do with the standard deduction or itemized deductions. In other words, they have to do with deductions. It's not with the gross income, it's not with the tax rate, it's with deductions. And in the case of the standard deduction, it's doubled. For a single taxpayer was running around $6,000, it's now $12,000. If you have a joint return was $12,000, it's now $24,000. And I was sitting reading, just warming up last night, and I'm reminded that yes, the standard deduction is doubled to $24,000 if you have a joint return, but if you're over 65 and you're married, you add $1,300 to that for each spouse, that's $2,600. So the standard deduction, if you're over 65 and you're married, both of you are over 65, it's not 24, it's $26,600. If you're single, it's going to be 12 plus $1,600. That is a very significant change in this new law, and if you read the folks that are doing their projections, there are estimates that 20 to 25 million people will no longer do itemizing. I don't know what the distribution here is in this room, but that's a pretty hefty number that will no longer itemize deductions because, you know, hey, if you were joint and you had a standard deduction of $12,000, but if you could get your itemized up to 15, well, you're going to itemize. You get it up to 18, you're going to itemize. You get up to 20, you're going to itemize. All those people are going to be much better taking a standard deduction. So that actually is one of the significant, large-scale changes in this Tax Act. So that's on the standard deduction side. What about your itemized deductions? A lot of those are going away. And I should remind us that exemptions are going away. They're gone. We used to be able to deduct, it was roughly around $4,000 per person. You know, if you had a joint return, you would each get $4,000 plus $4, about $8,000 as a deduction. That's gone. So we gave an increase in the standard deduction, but we took away the exemption. So this is very characteristic of this tax change. There are things that are positive for you, and then there are things that aren't so positive. And you can't generalize across a population. Everybody's different. It depends on what particular itemized deductions you have, whether you're in alternative minimum tax or were, and whether you will be now. So looking at itemized deductions, trying to go quickly here, let's think about, okay, what's still there? Let's look at what itemized deductions remain and what itemized deductions now are either reduced or have vanished, gone away. What's still there? You still have medical, and essentially it's the same. Actually, for 2 years, there's a slight benefit in medical deductions. You have to get over a hurdle amount before you deduct. They've dropped the hurdle from 10% of adjusted gross income to 7.5 for 2 years. But essentially, think of your medical as being roughly the same as what you had. State and local taxes, well, all of us in California, along with folks in New Jersey and New York, know that as high-tax states, I'm sorry, you're not going to be able to deduct those state and local taxes, those property taxes, except up to $10,000. That's a major limitation for us. Moving down to mortgage interest, I don't know if you folks have paid off your mortgage loans or not, but and I think the real answer is probably for most of you, there is not going to be much of a change because the existing rules for the deduction of mortgage interest are essentially grandfathered for mortgages that are in place. Okay? So if you happen to still have $1 million mortgage, God forbid, I hope you don't. Well, I don't know. Maybe you do and you have a really great house. That's my old father's Depression era, mantra in my head. You're going to be able to deduct the same interest. The rules have changed. If you buy a new house, they're going to let you deduct interest on $750,000 of a loan, but not more than that. So I think really that's probably in place for most of you. Charitable deductions. I know I had a lot of people asking me at the end of December and the beginning of January, am I going to be able to deduct my charitable contributions? There is no significant change from the old law. Your charitable deductions they're deductible just the way they were before. There's some planning opportunities that are going to look more attractive now because of the new law, but the deductions are all still there. There was one, and there used to be a deduction for, basically you give to the university, you get access to priority seating at athletic events. That's gone. Sorry. You look, I don't know, I'm not sure if this looks like that crowd, but that's gone. And there's another small change that benefits into how much you can take in a given year. But essentially think of it as unchanged. So medical is still pretty much the same. I think for most of you, your mortgage is still pretty much the same. We'll talk about one piece that isn't, and your charitable is. So what's not the same? Well, we know that state and local taxes are not the same. They're going to be limited to $10,000. What else is not the same? There is a small piece in the mortgage area. You used to be able to take a home equity loan out up to $100,000, and nobody cared what you did with it, right? You could buy a yacht, you could go to Greece, it doesn't matter. And you could deduct the interest. Well, you can't do that. And I don't care if you started the loan a year ago, it's not grandfathered, it doesn't matter, you can't have it. So that's a small change. The other big change that might affect you is that we can no longer deduct a category of expenses called miscellaneous itemized deduction. The big one that I'm thinking of, if you have investment portfolios and you pay Merrill Lynch, your wealth advisor, or your Raymond James and Trevor here, good money to manage your portfolio, I'm sorry, you can no longer deduct those fees. So I'm thinking you maybe...
You still get your tax deduction for tax privilege.
No, I'm sorry. You can't deduct my fee either. And bless Congress, they actually listed the tax preparers separately. Everybody else is in a bundle. You can't deduct the miscellaneous itemized deduction, which of course includes all these 13 things. And oh, by the way, we have a special line item that says you cannot deduct the payment you make to your tax preparer. Thanks a lot. That, again, if you have those investment portfolios, that could be in effect there. So,
Excuse me, you said tax preparers can be deducted or cannot?
I'm sorry, they cannot be deducted. Okay. What I see happening and I think it may affect some of you, so that's why I've chosen to focus on this piece, is this issue of whether you're going to take a standard deduction or whether you're going to itemize deductions. And that's something you need to look at. And there is, in looking at that analysis, there's going to be a couple of things you actually may have some control over. And the two that I can think of are medical and particularly charitable. And the reason I'm picking those is you have some choice in where you place those costs, what year, so that if you have elective medical costs that need to be done, if you position them in a particular year, and if you're charitably inclined and you give a certain amount every year, if you can position 2 or 3 years of charitable deductions into that same year as the medical, you have now got a really hefty bundle of itemized deductions, which will exceed the standard deduction, and you will get the benefit of that. And in the years that you have left a little sparse, you're going to get the standard deduction. So there is some planning that you're going to be able to do, and particularly I think in the charitable arena, and that's kind of the intersection with some of the other comments, that probably the most effective vehicle for bundling your deductions is going to be a donor advised fund. And I see you have someone here from Fidelity, and I know they work with you. Ron? Yes. And I know Fidelity has a donor advised fund. So, if you come to do planning and you're looking at doing something like this where you're going to load up your deductions and get the benefit of an itemized deduction in a given year, you can make a contribution to your donor advised fund, and then basically that can cover your normal annual deductions for 2, even 3 years. They'll be coming out of that donor advised fund. But you advise that, and some of you may even use this already. So there are going to be some opportunities to actually plan with this new decision between, do I use the standard deduction or do I do the itemized deduction? And one final thing on charitable there, and I know we had some questions sort of in this area of required minimum distributions. If you're in a situation where your itemized deductions don't really quite reach that standard deduction, you're going, oh darn, I give $5,000 to $10,000 a year to charity, and I used to get a deduction for it. If you make that charitable deduction directly from your IRA, and it must be direct, it qualifies for your RMD, for your required minimum distribution, which you need to take. It qualifies for that, but it's not income. So it's not in your income, and so you're actually going to get the benefit of that, and you're still going to get your standard deduction if you fall into this particular paradigm. So that's just a planning thought that folks may follow up on. And then I guess I should make sure I conclude with just a comment on estate and gift tax. You may know or may not know that there was a significant change there. It's pretty much one big change. It used to be that you had a lifetime exemption of $5.6 million in this year to gift or to bequest on your. Is it good? Did I add right?
Yeah.
Oh, good. That is now going to double. So individually, bless you if you have this much. I didn't invest that well. It's 11.2 million each person. So if you're married, that's 22.4 million, and you can give away during your life or when you're dead, or provide for it. So when you're dead, that's the big change in in gift and estate. And Tyler will comment on that. The things that are still the same, although it may not have the same kind of meaning because of the size of the exemption, the big exemption, you can give $15,000 a year to any individual, and that doesn't eat into your lifetime exemption. You can gift and pay tuition directly for a grandchild, that doesn't eat into that exemption. You can pay medical costs for folks, again, if paid directly to the hospital or the medical provider, and that does not eat into that large lifetime exemption. I think I probably took more than 8 minutes. I better stop. I need to remind you that at the end I've got a handout for you.
Thank you, Larry. Larry's actually covered almost all the points that I was going to make, so I'm going to reinforce them, yes. So I'm going to talk a little about, obviously, the Tax Cut and Job Act. In a broad sense, what it's doing to the economy. Can you hear? Okay. And what are some of the impacts of this, and then what is happening in general. Reinforce a few things there about qualified charitable distributions, and then move on to the estate planning aspects. So one of the things that's happened with this is it's encouraging the whole development of the economy. We know that these tax cuts, we're going to have more money, but particularly in the businesses. So we know for the future, the economy is going to be doing so much better in general. Against what has been happening in the past, we're at the end of what is called a secular bull market. So we still have many more years to run in comparison where we've come from the financial planning debacle of 2008. So that's the secular bull market we're recovering from. And then the rest of the world is recovering behind us. So we have these aspects, these are all tailwinds that are going to help with our investments. Why is that important? Because it's going to be, how do we invest for the future within your 403Bs and IRAs and so forth. The other thing that's going to happen as we see it is interest rates are going up. So if you've got bonds and so forth in your portfolio, interest rates going up. We've had 30 years of declining interest rates and bond returns. So most people are familiar with this cycle. I know there's Professor Michelson in here. We've started at 20% Fed rate, and we went down to 0.25. And now we're creeping back up again. In the next 2-3 years, we're already at about we end up at 2%, 3%. That's a big change. Most people who have been in this economy haven't seen that, and they're not used to that change that's coming. So I'm going to move from general inflation and then talk about the qualified charitable distribution. Larry talked about that. One of the things about that is you can donate up to $100,000 per person. So that's $200,000 for a family. And we were getting a whole number of questions about required minimum distributions. As Larry said, if you make a direct payment to the charity from your IRA or your 403B, then you get a qualified distribution. It's as if you took that money, you don't have to pay taxes on it. We've also got a question about, can I do this with a check? When there's no check writing generally from an IRA, so you have to do it as a direct transfer from your brokerage account, your IRA, and then transfer it directly to the charity. So that was a question that came up earlier. Charitable deductions, Larry's already touched on that. donor advised funds, if you're going to chunk up, you bundle up these charitable deductions, it's a very wise way to do it is to use a donor advised fund. Another one that Larry, is appreciated securities. If you've got assets that are, one is a house or property, we were talking about that earlier, but also stock assets in your portfolio. You can donate those to the university and they will happily accept them. Rather than selling them, taking the tax hit and then making the donation. Makes a lot more sense. We alluded to the estate planning taxes on estate planning. In 2008, if you had an estate of $2 million, then you had to do tax planning. And one of the things we'll talk about is many people have not touched their estate plan in 5, 10, 15 years. All these changes in the tax law mean that you should really, if you haven't touched your estate plan in a long time, you really do need to go and have a look at it because there are absolute implications. You may have written bypass trusts in the past and all kinds of things, so they need to be looked at. When we moved to $11 million, $11.4 million, that was only 5,500 estates, 0.2%. Now that we're at 22 million for a family, we're now at 0.01, 0.1% of all the estates. So it's, but that's given away $7 billion. So it's going to add to the deficit that we're going to see in the years ahead. The thing that we didn't touch on is some of these laws, like the estate planning, this is going to sunset in 2025. So we think we've got this. We can ignore all this estate planning, but who knows what's going to happen in just a few years' time. So we actually definitely have estates that are on the $10, $11 million. We thought we can get, not have to, we had to do planning in the past. In a very short period of time, we may have to go back to doing that. So it's really
Say
uncertain.
again when the sunset is?
2025.
One of the things I put in my notes 7 times to remind myself I forgot, and that is not only do the changes in the estate and gift tax arena change in 8 years, they sunset December 31st, 2025, but almost all of the individual changes that I spoke to you about, they also change at that time, and they go back to the way the world was last year. This is called a very crazy tax law.
So lastly, I'm going to just talk a little bit about estate planning. Obviously, for most people, we don't need to worry about tax planning for estate planning because most of us are not in the 99.9%. So there are many other reasons why we need to do estate planning, and certainly that's what we've seen in our families. Charitable giving, an important part, and you're both going to talk about that. Avoiding probate and publicity. If you give a gift, your family are going to inherit a significant amount of money, if you don't have an estate plan, that information will be public, and it goes through probate. So it's really good to protect your family from that. Maintaining control in blended families. If you've got stepchildren or you've married multiple times, then there are reasons to help manage the transfer of assets and values. Special needs or troubled heirs. We see all kinds of issues with alcohol, drug, impairment, and things like that. So if that's in the family, then that might be something you want to help protect them from creditors and so forth. And the last one, very personal, international marriages. If your spouse is a non-US citizen, it's not an unlimited portability and unlimited marital deduction. It's it's only $139,000. So that's a significant one if you're married to a non-US citizen. That's me. So if you have not looked at your estate plan in the last 5 years, definitely needs to be done. Okay, Tyler.
Yeah, and I'm going to talk very briefly about the tax implications with estate planning. A lot of what I'm going to do is I'll talk about estate planning in general, kind of give you guys an idea. And if you decide to tune out, here are the key things. You should have a relationship with an attorney. If you don't have an estate plan, it's really important that you find someone that you like and you trust and who you also think might outlive you. I think that's a really important principle. That you can have regular conversations with. If you have an attorney, I think it's really important that you set up opportunities to meet with them, I'd say every 3 to 5 years. I'd say just based off what might happen in the law, what might happen in your life, I think it's really important that estate planning, it's not a one and done thing. It's an ongoing process. It's something that should be reviewed and updated and assessed, especially given the current administration and the current tax implications. And also understanding that what we have now might change in another 3 years or 4 or 5 years. And that prior to this year, prior to this administration, they were always hinting and suggesting at reducing the estate tax exemption from $5.4 million back to $1 million, since that's a potential significant chunk of revenue that we can use to pay off our national deficit. And so it's important not to simply skate by based off what's happening, but to understand what you've done, why you're doing it, and if it needs to be updated. In the estate plan, I'll be very general, and I want to touch on some things that I saw a lot in my own practice. It's more than just a will. I think 80% of people over the age of 65 typically have one. So hopefully I'm talking in some redundancies, some things that you've dealt with and spoken with your attorneys. But it's essentially a comprehensive plan that deals with the distribution of your assets, the creation of your legacy, but it also can help you pay less in fees, court costs, and possibly taxes. Possibly. There are a bunch of different taxes that are implicated with poor estate planning. If you don't have a plan, which is actually a very common strategy for a lot of people, then there is that process that Trevor spoke of called probate. And essentially probate is the process by which your assets first pass, it's the legal process that your assets first pass to your creditors and then to your heirs. I say that because historically it was created because creditors would be very frustrated when someone passed away and then they couldn't receive the money they were owed. And so it exists in most jurisdictions for that reason. As Trevor mentioned, it's not ideal. Most people don't like it. It's completely public. If I were to pass away, someone could go to the courthouse and see what my assets were, who I had them with, and then who's receiving them. It's lengthy. A really fast probate might take 9 months, but I'd say on average they're going to take more than a year. And if it's really ambiguous, if it's really combative, it's going to take a lot longer. I have a friend of mine in San Jose who's now working on his 11th year of a probate. Which is it's very messy. Yeah.
Trevor, could I ask if you would stand at the
sure.
The backlighting is more favorable.
Oh, great. As long as I look better, that's all that matters. No, and so he's in his 11th year of a probate, which is pretty outlandishly. It's essentially the estate before it's administered will be drained through this process. And what's most important about probate is that it's costly. The California State Bar estimates 4 to 7% of the value of the estate is lost in probate. And if you own a house, which is most people's primary large asset, it's the fair market value of that house. So if you have a $1 million house, then 4 to 7% of the value of that house is lost because a lot of the costs of probate are based off a percent of the estate. That's what the attorney, they get a percent of the estate, the executor gets a percent of the estate, There's a lot of costs associated with it. So it's not a great process. There are some other methods of distribution that people can use or have some ideas for. A very common one is a will. I think a will is a good document, but it does not get you out of the probate process. That's a process, or that's a document that the courts use to interpret what they should do. I essentially call it filing a lawsuit against yourself with your assets, because the first thing the court has to do is prove the validity of the will before they can start administering the estate. But at the very least, it does give them an idea of what they should do. Another common thing that I've seen is people just like to retitle assets and throw an heir on an asset. Not an ideal strategy. One being, if the person you throw on that asset, perhaps they have some sort of legal problem and a lawsuit's filed against them, then that entire asset, let's say it's your home, you just threw them on that, that entire asset could be subject to a retribution in some sort of legal action. And then also, it doesn't necessarily bypass probate. If you have a bank account with a couple $100,000 in it and you pass away, it doesn't just automatically go to that person. They need to take that asset and put it through the probate process first. Another thing a lot of people have with their homes, I see this very commonly for people that bought their homes a while ago, is they might own their home in joint tenancy. That's good in that for the first passing, the first person who passes away, you avoid that probate process, but it does not avoid the probate process when both joint tenants have passed away. And then there's also some pretty catastrophic repercussions under these circumstances with regards to capital gains, where the person who inherits the property as the surviving joint tenant, they do not get a full step up in basis for capital gains purposes. They get a partial or 50% step up in basis for capital gains purposes. So you don't minimize that tax. Another thing that you can do with your retirement accounts, perhaps with your bank accounts, is you can designate beneficiaries to receive those accounts, and they receive the accounts outright outside of probate. For the most part, I think this is a pretty viable strategy, but it also depends on who you want to have receive those assets. One thing I always tell people to be wary of is if you've named someone under the age of 18 to be the beneficiary of one of those accounts, then that might pull the asset into probate, because children under the age of 18 cannot receive more than, I believe it's $20,000 outright. It needs to be stewarded, but there are some institutions that allow you to name a custodian of the beneficiary so that they can receive the asset. This person can come in and manage the asset for them. But I'm not exactly clear. I think often when the person turns 18, or it might be 21, then I believe they are subject to managing it for themselves. And as somebody who was formerly 18 or 21, I should not be in control of any large sum of money. I barely can now. So most commonly, people have a living trust. That's essentially where you put your assets in a trust for your benefit. You appoint who can handle the estate and your assets in the circumstances that you pass away. It's kind of a legal fiction in that you're basically entering into a contract with yourself, telling yourself what you're going to do with your assets while you're alive, and then what will happen with them afterwards. It's good because it does avoid probate. There is usually a cost to administering a trust, but it's less than going through the probate process. The big thing here is you just have to make sure that certain assets are titled in the name of the trust so that it works. Very commonly that doesn't happen, and when I used to do estate planning, people would come to me after someone would pass away. We would administer half their estate through their trust, and then we'd have to administer half their estate through their probate. And this happened, I'd say, when somebody might refinance a house. They didn't know that they changed the title of the house, and so the house was not in the trust, and we couldn't get it in the trust. Ultimately, my main point, you should have a relationship with an attorney. The tax code was significantly different just up until 2009. My father had an estate plan prior to me becoming an attorney from the year 1999, which was very complex because it had to be. And it named someone to be the successor trustee that he had not spoken with in 16 years. And if something happened to my family, we would have had to go to court to undo a lot of that. We would have had to have done a lot of things to make that plan a lot simpler. And so right now, you do not need, typically, for at least tax planning purposes, you don't need an incredibly complex plan. It's really circumstantial in terms of what makes sense for you. But if you haven't updated it since, I'd say, at least 2009, it's very likely what your plan is asking your family members to do in the event that you pass away. It's very likely that's going to be pretty tough, or it's going to require a lot of extra work for them. And something I saw often was somebody would pass away with a trust that would divvy up the assets into a bunch of different trusts, and the trustees would have to go to court and ask the court to change the structure of that trust to make it simpler. So it's really important. Have somebody that you trust, have somebody that you can speak with, who you can update your trust with on a regular basis. Yeah, I think that's my biggest takeaway. Is not that much different given the tax change. Community property, just real quickly touching on this. If you own property as community property, you do bypass probate for the death of one person. But if the other person has not put it in a trust, then upon their death, it would go through probate. So again, it's really important to have a comprehensive plan that covers a lot of everything. Yeah, so that's generally it for me. I'll pass it along to Virginia.
Question.
Oh, sure.
Per person, for we who are alive,
Uh-huh.
giving, let's say, money individually to another family member or to anyone, for that matter, how much can you give a year at this point and not have it be taxed or whatever? You
Well,
say 10,000 and 12,000.
so you can actually, so the estate tax exemption was raised as well as the gift tax exemption. So what happens is it still $14,000? It's $15,000? You can give away up to $15,000 to someone a year and not have to file anything with the IRS letting them know that you've eaten into your exemption. But again, since it's so high, $11.2 million, right now, if you would eat into it a little bit, there's not a lot of, it's still very unlikely you'll ever have to pay any sort of gift tax. And you would pay your estate, essentially, if you ever exhaust that exemption, your estate is the one paying that gift tax. So, yeah.
Thank you.
Mm-hmm. Sure.
Hi, this is just follow-up.
Okay.
Am I right in thinking that for those gifts, you don't do any reporting on your own taxes, and the receiver of the gift also doesn't pay taxes on that gift?
So you are, so if it's more than 15,000?
No, less than 15.
Oh, less than, okay. Yeah, no.
Per person.
Per person.
Per person, so that would be 30,000.
Yeah, so it's per person, and if you're married, and let's say you want to give something to your kids, you can give less than $15,000 to one of your children, and then your spouse can give less than $15,000 to one of your children, and you're not going to eat into the gift tax exemption. Yeah.
You mentioned that heirs of a couple do not get a stepped-up value for a piece of real estate on the death of the parents?
Oh, if it's community property, sorry.
If it's just joint property, both spouses eventually die, the children inherit the property, they don't get a stepped-up value.
They'll get a half stepped up value based off the death of the first person who has died. Whereas if they receive it, if it was community property with the right of survivorship, or just community property and one spouse dies, it goes to the other person, then at that time they get a full step up in basis when they inherit it.
Great questions, and I'm just going to give you a little bit of information, and we will start taking other questions. So I am in the legacy planning options business, and when I work with people, I always start with, what is your goal? What would you like to achieve? There are some people who want to give gifts today. And there are a couple of good strategies for that. They've been mentioned today. One is giving appreciated securities, like if you bought Apple stock when it was $16 a share. That makes a really good gift. The reason is you bypass capital gains taxes. It does not come out of your income, it comes out of your assets, but you can still take a charitable deduction. The second program has, I think, been touched on as well. That's the IRA rollover program, available for people who are 70 and a half or older. You can gift up to $100,000 per year. Per person. You need to make the direct transfer from your IRA custodian to the charity. And most charities like ours, the university, will have letters to help you initiate that kind of transaction. You do not want to receive the money first and then send a gift. You will be taxed on those funds. The thing about it is you do not get to take a charitable deduction, but again, it does not add to your income. And that's why I'm really watching this popularity grow, especially here over the last couple of years. We're getting gifts as small as $250, but as large as $50,000 pledge payments. So it's good to know. There are also 3 different vehicles that pay you income, and they have various names, but what Tyler and I do is we work with people to say which one would be most appropriate for you. And it sometimes depends on the asset. Their names are the Charitable Gift Annuity. It's great for cash gifts. The minimums are low. Charitable Remainder Trusts are a good way to sell appreciated property, actually. I'm hearing and seeing and watching and working on gifts of rental property. So some of you may own rental property, and I'm having alumni come and say, I don't want to be a landlord anymore. How do I dispose of this asset? I would also like to make a gift to the university. These vehicles allow you, again, to bypass capital gains, increase your income, and get a charitable deduction. So they're good tools, planning tools. We can provide you with illustrations that we will then encourage you to take to your financial advisors, your estate attorney, your CPA, so that you can understand the impact on your particular situation. And the last grouping of gifts are gifts that take effect after your lifetime. 90% of all of those gifts are straight bequests, and they can either be a dollar amount or a percentage. The other 2 strategies are naming charity as a beneficiary of your life insurance plan or your retirement plan. And the way that I advise people is, if you want your children to benefit from your estate, you might consider leaving your tangible assets to them. So, in my example, I'm single, I have a son, he's going to get my house and my life insurance and some other assets. But I'm going to use my retirement plans to make my philanthropic gifts, because if I use those plans to leave to him, he's going to be taxed on those funds. And so one strategy to think about is wanting to maximize your estate. So my own idea is I'm using my retirement plans to accomplish my philanthropic goals. The final option available is a retained life estate, and that is where a donor gives us their house, but they retain the right to live in it until they pass away. There are benefits to doing that. It's usually older people are interested in something like that. We actually had one here. It was a gift to the library, and the donor asked us to terminate the agreement early because she lived in Loyalton, California, very secluded, and she was losing her eyesight and her ability to drive, and she wanted to move in with her niece, who lived in Vista, California. So she came in had she passed. We have all of this information. I've got packets that we use and books when I'm working with people if they really want to think about a specific situation. Some people have a special needs child, there's a chapter in here on what do I do if I have a special needs child, how do I take care of them. I also have a guide to plan giving brochure, and we also have a wills packet that just helps you start gathering all of your financial information to take to your estate planning attorney or your financial advisors. And then we do ask you, if you have included the university in your estate plans, we'd really like you to share that information with us for a couple of reasons. One is we want to be able to thank you while you're alive and include you in our recognition events. But the second reason it's more important is we want to make sure we can honor your wishes. We sometimes get gifts that require other funds or other things that the university cannot honor, and we have to decline those gifts. And really, if the donor wanted to see something happen, we really want to make sure we can do that. So if we work with you, we can do that. And just a pitch for Tyler and I, we don't cost anything. We're a benefit from the university. Our job is to help you understand what your options are. If you go to your attorneys, they will charge you to educate you. They'll be happy to, but we want you to give you the information. We're happy to talk to you individually. And if you didn't get enough of today's topic, we do have a seminar that we're co-hosting similar to this one. It will be in May. We are co-sponsoring it with the Community Foundation of Santa Cruz County, and it will be on Thursday, May 3rd in this very room. We've, again, I mentioned that we will start distributing some handouts for you, but we're ready now to take some questions. Dan?
I was interested, one of you mentioned in terms of transferring assets from IRAs to a charitable organization. And somebody said, and I had not heard this before, N403B, that it's not just IRAs, but 403B. Is that accurate? That is, in terms of coming against required minimum distribution?
So my understanding is gifts from those programs must come from an individual retirement account. What I have seen people do is transfer money from a 403B to an IRA account and then make a gift. But you want to be very careful because I believe sometimes you're only allowed one transfer per year, and each time you wanted to do something that would be counted. So you'd have to transfer the funds 1 year and then make a gift the next year from that IRA.
Right. So the rules, in other words, are different for donating money from a 403B than they would be from an IRA. I mean, my wife has an IRA, but my money's obviously in 403B. Yeah.
Yes. Ron, do you want to add anything to that?
Yeah. So actually, you can transfer from an IRA or from a 403B to an IRA with your plan here at the university more than once. So the plan does allow that.
Right.
Second, though, they are different. IRAs are much more flexible when donating and doing other things. So if you want to. What's great about it is if you want to here at the university transfer from your 403B to an IRA, it doesn't have to be all or nothing. You can do a portion of it if you want to and get it over into the IRA so that you can make those charitable donations.
And I assume that's all true if you're transferring into a donor advised fund.
Correct.
In other words, those are just in effect charities as far as the bottom.
Yeah, so basically what a charitable gift fund is, at Fidelity, is it's just a fund itself that you're putting money into and getting a write-off right then and there from that amount. But then you then can distribute to different charities across the board from that fund, from that account.
Okay.
What? Larry?
Yeah, I want to check. On moving, part of your required minimum distribution as a charitable contribution, using this charitable rollover from an IRA, I don't believe that can go into a donor advice fund, can it?
The charitable gift fund, yes, it can.
Okay, it can?
Yes.
You can move, you can move the contribution.
So, Fidelis Charitable Gift Fund is the second largest actual charity.
Right.
Next to, so you can go right to the fund itself with that. So it depends on the type of fund you're looking at.
Okay.
So please just check with your financial planner as well as your.
But in your case, it will work.
It will.
Okay.
Yeah, we do it all the time.
Michael?
Yeah, you have to say anything else, you know, at our age, we always come up about children dollars and grandchildren.
Yeah.
And I understand, and you should know, you can transfer funds to education. You want to say something about that?
Sure.
It's a really good question. We were talking about the deduction that you can get each year. So you can do what is called a 529 fund, and as two grandparents, you could actually put $70,000 into that. Two of you, $140,000, and that's funded for 5 years. Basically, you're allowed to accelerate that deduction that we were talking about, $15,000 a year. You can accelerate it so you get 5 years in one go. And that's a really nice thing to do, because as long as they use it to fund a qualified education, then it comes out tax-free after all the growth that's gone on.
But there are different organizations who handle this. Do you have any comment about that?
No, 529. It depends sometimes if you know where the kids are going to go to college, but often you don't. So they're all very similar. It's what choices do you have to invest in once the money moves over. And one thing I think Larry alluded to, 529s now can also be used for high school and kindergarten education. It's not only higher education. Correct?
Yeah.
Next question.
I know that we're all concerned about the impact of the limitation on property tax, state taxes. I heard, and I wonder if you know of any substance to this, that there was a move afoot in the California legislature to have these state taxes imposed as a form of charitable contribution to the state as a way of avoiding that limitation. Is that just pie in the sky, or is there something like that in the works?
There are a number of folks trying to put something together. The general sense from most tax practitioners is that it isn't going to work. And the route that some of the California legislators were trying to take was, as you said, to create a fund where you could basically contribute, get a deduction, and then that amount would offset your taxes. The trouble with getting a contribution is a contribution must have donative intent, that it must be a gift. It can't be done to get something back. Seems pretty clear that this whole thing is designed for you to get something back. So most of us feel that nice try, but it ain't going to work.
I'm thinking something else.
Yeah. Yes?
Yes, property was mentioned, but if you're single and want to give a piece of property to a family member through a trust, is there a tax on that up before that $5 million or whatever it was, or not? Or I was hearing something about stepped up things.
Oh, the step. No, I mean, going back to your original question, right now, you say you're single, you have $11.2 million to work with. You can gift, if you haven't already used some of that in prior periods, if you haven't already gifted large amounts in the past.
Well, what if you gifted it to charity?
No, let me distinguish between a gift to charity, which is a charitable contribution. I'm thinking of what you're asking, which is a gift to a family member or some other individual. Gifts in that space to family members or other individuals, you have today, you can make gifts of $11.2 million and not have any tax. Now, as I think it was Tyler who said, you know, when we're talking about these annual gifts of $15,000, that simply means you don't have to file a gift tax return. So if you gave a gift of $100,000, you would have to file a gift tax return. The gift tax return would say, hey, I gave $100,000 to my son. $15,000 that doesn't have any gift tax. That leaves me $85,000. The gift tax on $85,000 is X. I'm using part of my $11.2 million to cover it. I have got no tax. But you have to file a gift tax return if you go over $15,000 to and a single individual.
Per year, Melanie was saying, I think I heard this before, that the receiver, if the receiver receives over $15,000 when you're alive, they have to pay on that.
Oh no, the recipient of a gift is never the person responsible for the tax. It's always you guys giving. You guys are the ones that are responsible for the tax.
So let me understand something. I'm always puzzled about, you know, if you exchange funds between your family, say, just to give an example, I want to give my kid $100,000. How do you know I've done that?
I don't.
So,
But you have to fill out the form.
What if there's nothing is in writing and just, here's a check, go get the money. I mean, what's the big deal? I mean, how does the government get involved in this?
Well, if it's cash, someone over here had that comment. The government does report cash transactions, generally 10,000 and up. But it's true that this happens all the time. Family members do move money among one another, and it isn't reported. And obviously, you might say to me, and just as you have, well, why does it matter? You're telling me I can give $11.2 million to people and I don't owe any tax. All I have to do is file a gift tax return. So, yeah, as to whether the government's going to be concerned about smaller amounts like that transferring. But we're only simply telling you what the law is. The law says you go over $15,000 to an individual, you need to file this gift return. And do they know? No, they don't know unless for some reason they trip over it. Yes?
I have a question which partly involves the cost here. I can't remember whether your names and contact information was actually given in the email that was sent out about this meeting. So if that full information, your names and contact information of the experts was not given to us then, would Todd be willing to undertake to circulate that by email to us?
Yeah, we'll send it out. The contact information was not included. The names were.
Okay.
I very much appreciate that. I think that was my clue. Thank you very much.
You're very welcome. Question?
I have a question about my 4CD plan. Basically what happens after I have beneficiaries, which I designated. Now, does the money stay in that account and just be transferred to the people as beneficiaries, and then do they have to pay minimum required distributions every year, just the way I have done, or is it based on...
Yeah, I actually had to do a lot of research on this morning, so, and Ron will correct me if I get any part of this wrong. So, at the point where you pass, your kids, I'm assuming kids, someone who's going to inherit, have about 9 months in which to make a decision. If they don't make a decision, the university will pay it out in one lump sum. Right? There's two other options. One can be over 5 years. There's a 5-year payout. They can opt to do that. Obviously, that's less of an impact than having the money in one shot. or they can transfer that money, the assets, into an inherited IRA fund. And then at that point, it's the decedent's required minimum distributions. It's not the kids. So they start paying out required minimum distributions against your expected lifetime. Correct, Ron?
To an extent, yes. The UC actually uses lifetime expectancy on payouts. So
oh, you do your own? Okay, got it. Okay.
The default is lifetime expectancy rather than the default of the loan.
Oh, okay, right. When I read the plan document, it was the other way around. Okay. Thank you.
Does that answer your question? That was 45 minutes of research work.
Todd? And you'll be our last question. We will also stick around if you want to ask any of us any individual questions.
Generation skipping, where you give to your grandchildren, that exemption is also the same as the inheritance exemption?
Yes, they're exactly
11 million or whatever?
Yeah, they're all
yes. The estate tax, which would occur at your death, the generation skipping tax, and the gift tax. Well, the gift and the estate are bundled together. That's 11.2. You also have a generation skipping tax exemption of 11.2. A lot to work with.
Thank you very much. We appreciate it.
I'd like everybody that's remaining to give Virginia and all of our panelists a hand.
We're happy to stay around and answer any more questions if people have.
Can you also bust your tables so you have screen in the back?
Good for you. I can tell. I am. No, I'm married to an American, but I'm a Brit.